I hope I'm not preaching to the atheist choir tonight. I was not sure of the makeup of our gathering and wanted to share the knowledge of important court cases for the secular community with other atheists. This particular group has a great deal of information concerning such cases already. But when I was researching for AtheistScholar.org, I found many things I did not know, cases, and also the way those cases fit with other judgments, and particularly the resonance those cases had down through the years. I think we all have some things to learn to fit the pieces of the legal puzzle together, and what that puzzle, unfinished and uncertain, means to non-believers in the United States. When I mention references that say see sociology, for example, I'm referring to sections in AtheistScholar.org. I have also been thinking about the many centuries from the ancient world through John Locke's time to the present concerning the enormous difficulties we atheists have with the public perception. No matter how wicked people may be, it seems that people think we atheists will be even more so, since we do not subscribe to some sort of supernatural belief in a transcendent other and a life beyond death. I think the kind of thing the Freedom from Religion Foundation is doing is excellent. Their latest campaign showing normal, non-believing people from all walks of life and all ages was extremely beneficial. It's not a bad idea to show famous atheists living and dead either. We need to concentrate a great deal of energy on the effort to show not only can people be good without God, but to show that there are many of us atheists who are pretty good without God. I think until we can get such a concept across to the public, we will continue to suffer legally, socially, and in the workplace. We not only need to win in the legal arena, we need to change people's minds and hearts about us. Atheism and the law. Most Americans believe that their religion or non-religion is a private matter of no concern to other people. Many of them are astonished when they learn that such a concept is a fairly recent historical innovation. There was most likely no separation of the religious and secular spheres in early societies. Religious sanctions reinforced social customs. A member of a primitive tribe who violated a custom violated a taboo which could bring upon him the wrathful vengeance of a non-human mysterious power. Eventually, a need was seen for an intermediary between the earthly tribe and the supernatural powers it worshipped, and the priestly caste emerged. From the very beginning of human history, however, it was the king and not the priest who was superior. Such a state of affairs lasted for centuries, and although the waxing and waning of church power upset the balance at times, hegemony always eventually reverted to the realpolitik of state power. The beginnings of religious choice and freedom came slowly for human societies. The Papal Edict of Milan in 311 CE was an affirmation of religious freedom, in that every person was stated to be free to manage divine affairs to his own choice. It is of interest to note that no stated freedom was extended to non-believers who are not mentioned in the document. The influence of Augustine, Bishop of Hippo, writer of City of God, 426 CE, on the course of religious history has been non-salutary and egregious. Augustine maintained it was just to use coercion in order to use heretics of their error, and even to punish them if they continued in heresy. His position concerning coercion remained the official stance of the Roman Catholic Church until the 1965 Second Vatican Council. 1965. Augustine's influence was an important justification for the medieval church's practice of persecution of heretics, often with the most violent measures. Such practices included torture and putting those citizens who differed from the church's official positions to death by burning, auto de fe, or act of faith as it was called, and other means. Atheism was a legally unprotected philosophical position for centuries. Since the legitimacy of the pre-modern governments rested on claims of divine right, atheist non-belief in divinity threatened the stability of the government. The philosopher Plato in 5th century BCE Greece and Thomas Aquinas in 14th century CE were both supporters of the death penalty for repeated offenses such as impiety, blasphemy, or being an infidel. The church carried out such extreme measures very often. What is most noteworthy, however, is that trials for blasphemy have been conducted outside of church jurisdiction by jurists under the cover of common law until relatively recently. The tradition of religious liberty in the West is due in great part to such classic liberals as John Locke. His years are 1632 to 1704. However, Locke did not extend his advocacy of toleration for diverse religious creeds to atheists. He was afraid atheists would undermine the courts and the economic structure of countries, as he maintained they could not be trusted to uphold oaths, covenants, and contracts. Pierre Bayle, a contemporary of Locke's, argued for toleration for non-believers. Bayle was a skeptic who maintained that since man was regarded as autonomous, the right of making a decision to believe or not believe in God should be a private matter. After Locke and Bayle, it would be 200 years before the idea of religious tolerance would be extended to non-believers. The American experience with regard to church-state relations is somewhat of an anomaly. With the ratification of the United States Constitution in 1788 and the Bill of Rights in 1791, the American government extended a very broad right to religious freedom to its citizens. Nevertheless, atheists are discriminated against in our country, and attempts to prioritize religion above non-belief are persistent. Many historians and legal experts have noted the anomalous nature of the United States with regard to religion and secularism. We have a secular government founded largely on principles the framers of the Constitution had received from the European Enlightenment. At the same time, the majority of our population is deeply steeped in religious belief. Such a populace has an unfavorable view of atheists, and at present, an atheist has very little chance of being elected to public office. There is an unrelenting campaign on the part of religious fundamentalists to breach the wall of separation between church and state. Our country has one of the oldest constitutional injunctions against religious establishment, has a specific constitutional provision prohibiting religious tests for public office, and has an honored legacy of constitutional theory articulating the need for a wall separating church and state. Yet, over the last 30 years, religious fundamentalists in league with religious, or in some cases pandering politicians, have made limited but significant gains in their struggle to Christianize America. C. Welton Gaddy states the situation succinctly. He calls the state of affairs in the United States the religioification of politics and the politicization of religion. A look at atheist history with regard to the law in the United States confirms the fact that atheists have been discriminated against time after again have been forced to go to the courts to obtain rights already guaranteed them by our Constitution and Bill of Rights. Christian fundamentalists have had some purchase with their falsehood that the United States was founded as a Christian nation. The facts do not bear out their claim. Colonial America, according to Sweet, had the largest proportion of unchurched in Christendom. Even in New England, the most church section of the 13 colonies, there was not more than one church member to every 8 persons in total population at the close of the colonial period. Church affiliation out of the total proportion of the country at the founding of the Republic was limited to 4% of the population. Undoubtedly, the lack of ministers and distances between churches were large factors in the paucity of church affiliation. But it is almost a certainty that those people who are not connected to a church will not persecute others for the same thing. It also stands to reason that such citizens would not countenance being taxed to support a religion they were unaffiliated with. Nevertheless, atheists and agnostics have suffered discrimination under the early laws of individual states in the colonies, and also from subtler but insidious discrimination from our courts for many years to the present day. The experience of the American colonies led some forward thinkers to reassess the wisdom of merging religion and government. In Massachusetts, Puritans established a harsh theocracy that brooked no dissent over religious matters. Roger Williams, a Puritan preacher, challenged that view. Williams' views were deemed heretical and he was forced to flee the region. He purchased land from the natives and founded his own settlement, Providence, Rhode Island. Williams was especially troubled by the persecution spawned by unions of church and state. Forced religious worship, he once wrote, stinks in God's nostrils. In his book, The Bloody Tenet of Persecution for Cause of Conscience, Williams railed against state-sponsored religious persecutions. Wrote Williams, "I must profess, while heaven and earth last, that no one tenet that either London, England, or the world doth harbor is so heretical, blasphemous, seditious, and dangerous to the corporal, to the spiritual, to the present, to the eternal good of man, as the bloody tenet of persecution for the cause of conscience." In The Bloody Tenet, Williams spoke of the dangers of opening a gap in the hedge or wall of separation between the garden of church and the wilderness of the world. The use of the phrase is interesting, as it is very close to Thomas Jefferson's metaphor of a wall of separation between church and state. However, there is no evidence that Jefferson knew of Williams' writings. Williams' Rhode Island colony respected complete religious freedom. Even members of sects that Williams personally disliked, such as Quakers, found a haven there. But as other colonies were settled, different types of church-state arrangements emerged. Generally speaking, northeastern colonies were the most repressive. The Puritan church was established by law, and everyone had to pay taxes to support it, whether they were members of the church or not. Middle colonies such as Pennsylvania and Maryland were a little more tolerant on religious liberty matters. William Penn allowed anyone who believed in one God to settle in Pennsylvania, although Sunday religious observances were mandated by law. Maryland was founded as a haven for Catholics. The colony's Toleration Act of 1649 extended religious freedom to all Christians. The concept of toleration at this time was not generally understood to include non-Christians or non-believers. Southern colonies tended to be more repressive. Many of them officially established Anglicanism as the state faith and imposed church taxes on all citizens. Virginia maintained strict laws concerning religious belief and worship. Failure to attend church was a crime. Parents who did not baptize their children could be imprisoned, and denying the existence of the Trinity was punishable by a 3-year prison term. Despite these harsh laws, it was the issue of church taxes that outraged many Virginians. Their protest over mandatory financial support for religion was to have national implications and help shape the separation of church and state and bring a measure of religious freedom to the new nation.